Um, right, well, good morning, everybody. I'm Sam Kareem, and I'm a QC in Chambers and the head of the administrative and court protection team in Chambers. And my esteemed colleague, John Hunter, is with me today, who's also a member of the administrative law team in Chambers. Hello, virtually everybody. Well, I hope you've had a good morning so far. The purpose of really this part of the talk is to explain to you in as much detail as we can within the short period of time what administrative law practice or a practice in administrative law looks like when you're a barrister in Chambers. It's a highly specialized area of practice, as John is going to tell us about in due course and very shortly. And it's an area which really outside of London, only few chambers do in terms of breadth and knowledge. But it's an area which is extremely exciting because it deals with constitutional matters. It deals with issues which affect us on a day-to-day basis and our lives. So it's a very exciting area of law to be practicing in any event. So really it's to give you a bit of flavor, because I mean, when I did my law degree many years ago, I found that constitutional administrative law was the last subject that we studied in the final year, and it kind of wrapped everything together to kind of provide just a bit of a justification as to why we have all the laws in place. So it's a great academic subject, but today's all about how it actually transfers into practice. So I'm going to hand you over straight away to John, and who's going to tell us a bit more about what this area looks like in practice.
Thank you, Sam. Good morning, everyone. I'm aware that some of you are law students, some of you finished your degrees, some of you, I believe, are actually at sixth form. So I'm going to start, and I hope you'll forgive me for those who are familiar with this, with a little short introduction to what admin and public law is. Broadly speaking, I'm going to try and share a screen. So Sam, I'd be grateful if you can tell me whether this works or not.
Of course.
Apparently not. I think rather than delaying it, because I think we have got a short time, I'm not going to do this. I will send slides around so they can be circulated afterwards if anyone's interested in them. But broadly speaking, admin and public law is the law governing the exercise of powers and duties by public authorities. And the principles of admin and public law have largely been developed through the common law, that is, through judicial decisions over several hundred years, in fact. But it's now through a procedure which is, as I think Piers has been talking to you about in the context of planning, largely through the procedure of judicial review. Now, I think Piers also touched on the fact that though this has been judge-made and long-standing for several hundred years, there are moves afoot to make radical changes to it. There's a panel being set up by the government, the Independent Review of Administrative Law, which seems set to, well, at least potentially, make great inroads to some fundamental principles. And as a result, it is obviously a matter of fairly significant controversy. It's just at the consultation stage at the moment, so we don't really know what they're going to be suggesting. But if you're interested in this, and certainly if you're having interviews with public law chambers, that is something you'll need to keep a close eye on. So what is judicial review then? Judicial review, as I say, is the main procedure through which the principles of admin law and public law have been developed over the years. And it's the main way, not the only way, by which the senior courts supervise the exercise of power, as I say, and duties of public authorities, as well as inferior courts. What are its key features? Well, firstly, all claims for judicial review have to be brought in the High Court, save in a very limited number of cases that have been set apart by statute. There are certain judicial review cases that are brought in the upper tribunal now in immigration and asylum cases. But apart from that, the historic venue for it, and still the predominant venue for it, is the High Court. Well, what else is a notable feature about it? Well, in distinction from other forms of litigation, particularly civil litigation in ordinary private law claims, claims for judicial review are brought in the name of the Crown. So that's why you'll see in the law reports, it's always are on the application of whoever it is. It's only a nominal feature of it, because in reality, it's brought by whoever is named as the person making the application. But that reflects the historic basis of the jurisdiction, which is the courts exercising the king or the queen's power to review subordinate bodies. What else is distinctive about it? Well, it can only proceed with the court's permission. So normally that means you have to establish that the claim is at least reasonably arguable. Sometimes there are other requirements or other factors in play, but there's a threshold test which roots out quite a significant number of claims to begin with. Another feature of judicial review is it's subject to very short time limits. The general time limit is expressed like this, that you have to bring your claim promptly and in any event within 3 months. But there are certain categories of case. Planning cases, for example, which Piers has been talking about, is one where now the time limit is shorter than that. It's 6 weeks, and there are also other cases like that. Another crucial feature of it is that it's not an appeal on the merits. It's a review. And what that means is the judge won't be interested in hearing whether the decision of X public authority or Y public authority is right or wrong. What they will look at is whether it was lawful in accordance with the established principles that I mentioned before. It also follows from that its remedies are distinct. So if you are successful in a claim for judicial review, what normally doesn't happen is that the judge reverses the decision and makes the decision that he or she thinks is the correct one. Rather, the normal order is that the decision of the public authority is quashed and sent back for them to remake in a lawful manner, but without saying how it should be done. Sometimes you get other remedies. You may get a mandatory order, for example, if the claim is based on an allegation of failure to comply with some statutory duty, for example. The court may order the authority to comply with its duty if it has no other options. And then there are other remedies, such as a prohibiting order, if they're proposing to do something that's obviously unlawful, or a declaration if the parties just need to know what the law is in order to guide their behaviour, for example. Another distinctive feature is that it's rare in judicial review for there to be cross-examination of witnesses. It's not something that never happens. I've done it on 2 or 3 occasions, but it's definitely the exception rather than the rule. And then the final feature I would point out is that as Sam said at the start, this is a very specialist area now, and it's become a specialist division of the High Court. So it's judicial review claims go through the administrative court or some sub part of it. For example, there is a planning court, which is effectively part of the administrative court. And you have specialist judges dealing with all of that. What bodies are subject to judicial review? I started off by saying public authorities are subject to judicial review. That's broadly true, but needs some caveats. The first one is that not everything that a public authority does will be subject to public law. So, for example, if an authority is just entering into a contract, for example, for the purchase of paper clips or something, a local authority buying those, that's unlikely to be subject to judicial review because it's not inherently a public, a governmental function. On the other hand, the flip side of that is there are in certain exceptional cases, bodies which are not set up by statute and are not what you would think of as the government can be subject to judicial review. So there are, so this is the exception rather than the rule, but on the edges of judicial review, there are certain bodies that have been held to be exercising such power and the nature of their power to be so essentially governmental or public that they are subject to judicial review as well. In terms of the public authorities, the main defendants, the main people whose decisions or actions or failure to act are the subject of claims are central government, different departments, Home Office, Immigration and Asylum, prisons, and local government. So again, local planning authorities are a frequent target of judicial review, but also local government in exercising their other functions, as an education authority, a highway authority, for example, in the case of the sort of stuff that Ruth does. And also, if you were following the news last year, you'd have seen that in terms of central government, that stretches to even the Prime Minister. So if you followed the prorogation case, that was a case about the Prime Minister's actions in advising the Queen. And obviously there was quite a lot of controversy about whether or not actually what he did was reviewable at all, but the Supreme Court concluded it was. Right, that's my overview of judicial review, and I apologise, as I say, for all of that was very familiar to some of you. What then do public law barristers do? Well, I have to start by saying that there is a huge variety of work within the broad ambit of admin and public law. So immigration and asylum work was, and I think still is, a fairly significant chunk of it. In chambers, we have had practitioners who've acted on behalf of claimants, but the majority of people who do immigration and asylum work in chambers will do so on behalf of the government, because a number of members are on what's called the Attorney General's panel of nominated barristers who are deemed fit to do that sort of work. Prison law work as well, that would also be for the government. Mental health work is something that's done in chambers. Court of protection work, as Sam's mentioned, he's head of that team. Health and social care work, planning, environmental, and a catch-all category, and one that I do a lot of my work in, as well as planning and environmental work, is local government generically. As I said, that encompasses a multitude of different types of case: education, judicial reviews, so for schools closing, for example, I've done several of those cases, highways cases, as I mentioned, public health topically, statutory nuisance, village greens rating, things like closure of libraries as well. If you are practicing in public law, depending on the exact split of your work, because some people combine it with other areas of work, and as Piers mentioned, if you are, for example, like me or Piers, someone who predominantly practices in planning and environmental work, you'll have a good chunk of inquiry work to run alongside it. But in terms of the public law work itself, a lot of it is advisory, because a lot of people want advice on it, and then it doesn't necessarily turn into a claim. So you'll have a lot of written work, conferences, remote for the time being, but in person in the olden days of 2019 and before. And I mean, that's the essential split. You will have that advisory work, and then you will have your court work. So you maybe have more permission hearings, because more claims go to a permission hearing than actually get to a final hearing, but you'll have a good chunk of final hearings as well. Now, why come to King's Chambers if you're interested in this sort of work? Well, in the past, again, Sam's mentioned this, in the past, and indeed outside our chambers and perhaps a couple of others, public law work was not very much available in the regions. It was something which was largely done in London, but that is no longer the case. That changed very significantly with the regionalisation of the admin court. So instead of being based just in the Royal Courts of Justice on the Strand, about 13 years ago now, I think it was, or 11 years ago now, sorry, the admin court branched out and opened up in regional centres, so Manchester, Liverpool, Leeds, and in Cardiff as well, and Birmingham and Cardiff as well. As a result of that now, Chambers work covers a really broad and diverse array of the sort of public law work that I've mentioned. And we have, I think, 4 silks, 3 as well as 3 others, as well as Sam, and around 30 juniors practicing in different sections of public law. And as I say, the clients range from central government, local government, lots of local authorities, NGOs. For example, I'm acting on behalf of 2 environmental bodies who are judicially reviewing the Environment Agency, businesses, individuals, of course, as well. Another reason why you may want to consider King's if you're interested in this sort of work is that our geographical reach now isn't just limited even to the centres out of which we are based. So, for example, Sam has been recently instructed with a number of other barristers on behalf of GAY nightclub in London to challenge the 10 PM curfew rule brought in as a result of COVID. Sam and I, another example is Sam and I previously were instructed to advise on the low emission zone rules in London, the charges associated with that. So as I say, we're not even limited to the 3 centres we have. The work stretches out across the country. One other reason, a pretty important one, but one that's not unique to this area of work, is we don't offer Hunger Games pupilages, and by that I mean you are not fighting each other to the death if you get a pupillage in chambers, because there's only 1 or 2 spots available. Every pupillage is offered with a view to you succeeding and being made a tenant, which is, I mean, it was a major factor for me, and I think a lot of people who come to chambers, because you know, if you're not interested in competing furiously with the people who are your colleagues and friends, it's a real advantage. Right. In terms, I've got a few more comments, Sam. I'll just see where I've got time. I think we have got time. Good. Sure. I've mentioned the split of work. I thought it might be helpful if I just, as I say, it's hard to give a comprehensive account of all the sort of work that you can do, because even within chambers, we all practice in all these different areas and everyone's practice is different. So I'm just going to talk for a few moments about the sort of work that I do, and I'm just going to focus really on cases I've recently done or that I'm currently doing. So I think Piers very kindly mentioned the Supreme Court case that I was involved in earlier in this year. That was a planning case about it was about the Secretary of State's decision to list 2 ornamental piers and urns from a famous sculptor from the 18th century. The issue was whether the Secretary of State had erred in treating them as buildings and putting them on the statutory list of listed buildings. And so that arose in the context of a planning appeal, and I was unsuccessful, unfortunately. In the end, we won in the lower courts and lost in the Supreme Court. But our argument was that no, you couldn't, because the only way to challenge the Secretary of State's listing decisions was by way of judicial review, and you couldn't challenge it collaterally by a sidewind in appeal proceedings. You could only do it through, as I say, the judicial review procedure. The Supreme Court sadly disagreed. In terms of the case I'm doing currently, I'm doing several judicial reviews of decisions to grant planning permission, one of a skyscraper in Birmingham, another one of Manchester City Council granting itself permission for a large car park. They involve issues, although they're planning cases, they involve all sorts of issues. So for example, the car park case, one of the main grounds is equalities, whether or not proper regard was had to the impact of this decision on, in particular, disabled people and children, because it's right next to a school. Another example of the case I'm doing a judicial review of the local government ombudsman, who, if you're not familiar with, is basically a person to whom you can make largely informal complaints. So there's a case I've got about that. And as I said, another one I've got running is a challenge to an environment agency decision to grant a permit for various works of what they call biomanipulation to the Norfolk Broads. And that's the one I'm bringing on behalf of the environmental NGOs. And that involves all sorts of issues about the Water Framework Directive and consultation as well. Right, that's a selection of my work, but as I say, it only covers a very small part of the spectrum of work in chambers. So I'll hand back to Sam, and maybe Sam will have something to contribute as well. Thanks, Sam.
Yeah, sure. Thank you, John. That was a very good overview of the type of work that we do and how it's very different from other areas of work. And I think one of the things I just draw out from that is that unlike any other area of practice, administrative law practice can be quite academic, which is the reason why I like it, because you're talking about applying basic facts to legal principles. And if any of you, especially those of you at university who've done moots, there's probably no better example of how an administrative court hearing goes than to compare it to a moot, because you literally have one judge, your opponent, and you are arguing points of law, applying facts within a short period of time, and that's how it goes. There's no jury, there's nothing else like that. You are simply arguing law. So it's, if you like, the academic area of practice, or like academic area of law, and you want to translate that into practice, then administrative law is a good idea in terms of moving forward. But otherwise, we've had a few questions, John, in terms of how this area is very different from others. And one of the questions is that how would you say that administrative law is very different from, say, areas of planning, environment, or court of protection? But John, I mean, if you want to just talk about how it is different in respect of planning, but I'll just say that when it comes to court of protection and mental health, plainly, when dealing with court of protection and mental health, there are going to be public law issues. And when I say public law issues, I mean that there are going to be issues relating to decisions made by central and local government. If they are going to be challenged, then they are no longer court of protection or mental health issues. They become public law or administrative court issues, and to challenge them, the only court we can go to is the administrative court. So the distinction is, whilst on the face of it can be quite blurred, it is quite crystal clear that when you want to challenge the decision, you then have to go to the administrative court. But does the same thing apply in planning and environment, John?
Yeah, I mean, obviously there's overlap. So sometimes in planning inquiries, you're arguing the law. It's different for a number of reasons. One is your tribunal is different. So in planning inquiries, you've got an inspector who's usually not a lawyer. Sometimes they are, but usually not. They're usually a planner or some other expert of some sort. So you have to tailor your submissions accordingly. You try to be light on the law and make it simple. That's one difference. But the major difference between inquiry work and high court work, even if it's in the same area of planning, is evidence. So in inquiry work, there's often vast quantities of expert evidence, a lot of cross-examination of experts, lots of factual evidence, lots of documents that you have to go over, and disputed facts and disputed judgments. Whereas in the judicial review or other related high court work, it's legal argument. So if you enjoy the law, as Sam said, if you're a bit academic and you like that side of things a bit more, and Piers mentioned this, and he said how people in my section in planning and environmental have different splits, and he gave me as an example of one who does more high court work because I like it, and that's totally true. And I'm very glad and happy that I feel very lucky that I've managed to do that, because I definitely prefer doing the legal argument rather than cross-examining planning consultants day in day out. I mean, I enjoy that as well, but I prefer the legal argument. So that's the sharp distinction between it. By the time you get to judicial review, apart from in those rare cases where you have cross-examination, and even then it's usually on quite narrow parts of it, the evidence is sort of taken as read. It's either agreed or it's dealt with in some other way. That's the main difference, I think.
Yeah. One of the questions that's been asked is, do you need experience and extensive knowledge of administrative and public law before applying for pupillage at Chambers? And I think the answer to that is no, because I mean, when you're normally applying for pupillage, I mean, you may be dealing with administrative constitutional law at your law degree. It's not covered in the GDL if you're converting, but you don't need massive knowledge in it. It's an area that I think you have to have a basic knowledge in when you're applying, but there's no prerequisite in terms of a minimum type of knowledge or experience. I think one of the final questions that's been raised, John, is that you mentioned NGO work. Can you? One of the attendees has asked if you could just expand a little about how you were involved with this, and then I'll go into just setting out very briefly my kind of caseload at the moment.
Yes, the particular cases I was mentioning, I'm instructed on behalf of anglers and people with an interest in bodies that have an interest in preserving the purity of water for the purposes of their angling activities. That's that specific case that I mentioned. I've done other work. There's a body called the Environmental Law Foundation, which does pro bono work really, and I do some pro bono work for them. So I sometimes get cases through them, and they're either from individuals or sometimes bodies who can't afford to instruct a barrister properly, on normal paying rates. But yeah, there's a variety of that. How do you get that work? Well, I think joining the Environmental Law Foundation is a good way to get it. As with all other areas of work, if you express an interest in it and talk to the people who do that sort of thing. So the person who's instructed me for the anglers is someone I've done work for about 12 years. Started with the pro bono case, actually, through the Manchester Civil Justice Centre. I met this solicitor on that, and I've got work from him from 10 years, paying work and some pro bono work as well. So you have to express an interest in it and get to know the people involved if you want to do that sort of thing. Sam, could I just pick up one thing about the question before that?
Yeah.
If you remind me, the extensive knowledge and experience in admin and public law.
Mm.
I agree, and I think that's one of, I'm going to tell a sort of sorry tale about myself. One of the good things I think about our chambers is we're a bit more relaxed about that. We understand that you come from different backgrounds. We understand that you might, for example, I was in that position. I had done some admin law work as part of my conversion course. I didn't do a law degree. I did philosophy and Spanish, so I converted to law. And when I had some of my interviews, we'd still not come on to judicial review. So I remember one particular London chambers, a very, very good public law set, one of the top ones, I had an interview with. And I crashed and burned in the interview because it was quite clear that they expected me to know judicial review back to front. And I hadn't got onto that in my course. And I think it was rather unfair because it was for those people who were like me doing the GDL, hadn't done 3 years of a law degree and didn't know. But I think for some chambers, it may be a problem. For us, I think we're more understanding. We understand that you may be at a different stage. And what we're looking for is an interest, an ability, I'd imagine. Sam, is that correct?
Yeah, no, absolutely. And I mean, just drawing from my experience, I mean, my pupillage was in clinical negligence and personal injury. And I spent the first 3 years of my practice doing that, and then slowly developing a practice in human rights and administrative law, and then moved to King's Chambers, and that timed with the regionalisation of the administrative court, and then it became the majority, if not all, of my practice at a certain point. So you're absolutely right. You don't have to have that knowledge or experience base, otherwise we wouldn't be here doing what we do. But yes, I mean, there's just final few things I just want to touch on, because we've got literally a couple of minutes before we hand over to our next bunch of speakers. Is that as John was saying, why administrative law? I think that's a really crucial point. I mean, it is at the forefront of all kind of major decision makings, and I think it's an exciting area of law to be involved in practice, whichever side you are. And John mentioned earlier that I'm involved in the GAY case, where we're challenging the 10 p.m. curfew, and to this morning we've just been instructed with two other barristers in chambers to challenge, if Greater Manchester goes into Tier 3, that decision as well. So it kind of demonstrates how exciting this area of work can be. The second thing I wanted to say is why King's? Well, King's has been at the forefront of public law for a long time, but more so since the regionalisation happened, which is probably a decade ago now, isn't it? Or just under a decade. The public law team was set up by an individual whom John and I knew very well, which is Mrs. Justice Frances Patterson. She passed away a few years ago, but then she became the public law commissioner and then a High Court judge. But she set up our team, and there is a book that we publish in her name in public law. And we are, as John says said earlier, we're at the forefront of public law in various areas, be it planning, community care, licensing, and other areas. And I think finally, the only thing I just wanted to say was that what tends to happen if you specialize in administrative law is that you specialize in various areas, because public law covers everything, correct? So it covers various decision making within various different subject contexts. And so sometimes you end up, like I'm doing now, working on a case where you're dealing essentially with a licensing situation. The next time, as John indicated, we were working on the admissions case. The next time I'm working on a procurement case, which is a purely commercial context. So the variety is there. And so if you like that kind of academic overview of public law and its application in various different areas, you don't have to know per se those subject areas by heart. You just need to know what public law is and then apply it. So it is an exciting area of practice. And I hope the last half an hour has given you a bit of an insight into what life at the bar is like for public and administrative law. But as John said, we'll circulate John's slide to all those who are interested at the end. But I'll hand over to Matthew. Thank you, John, for your time. And thank you, Matthew, for organising.